I have no understanding. Those were the under oath words of Donald Trump Jr. today when his temporary job title was witness number 21, called to the witness stand by New York Attorney General Letitia James to testify against his father. Donald Trump Jr. is a co-defendant with his father in the case, and because it is a civil case, the defendants can be forced to testify. There was a time when Donald Trump Jr. was the least likely member of the family to go to work for his father and eventually become a co-defendant with him. In a profile of Donald Trump's first three children in New York Magazine in 2004, in which they all cooperated with the reporter and were interviewed, there is this passage about Donald Trump's very messy and public divorce from their mother, who accused Donald Trump of violence against her in a book. The magazine article says, quote, Donnie blamed the divorce on his father. And that's perhaps not actually what it was, he says, a bit haltingly. But when you're living with your mother, it's easy to be manipulated. You get a one-sided perspective. He didn't speak to his father for a year. In that article, Donald Trump Jr., who didn't speak to his father for a year, made it very clear that though he is the firstborn and has his father's name, he knows he is not his father's favorite child. That status, he acknowledges, belongs to his sister, Ivanka. In the New York Magazine article, their mother said this about Donald Trump. He's not the kind of father who would choo-choo, goo-goo, noo-noo. He would love them, he would kiss them and hold them, but then he would give it to me because he had no idea what to do. Give it to me. The New York Magazine article gave the least attention to Eric Trump, something he is surely used to. Eric Trump, who is also a co-defendant in the case and will be forced to testify, occupies a revealing paragraph in the New York Magazine article that just might be everything you need to know about Eric Trump. Quote, Eric, who seems the most inclined to look on the bright side, believes his parents' breakup cemented a deeper bond between him and his siblings. Donnie, in a way, is like a mentor. He kept tabs on everything that my grandfather taught him over the years and that I was too young to appreciate. And I'm definitely closer to Ivanka because of it. She took me under her wing and raised me, took me shopping, tried to make me cool. Well, at least she tried. Ivanka Trump is described in the New York Magazine article as speaking, quote, in a Madonna-like European accent. And she is the most defensive about how easy their lives have been. We've all made peace with the fact that we will never be able to achieve any level of autonomy, says Ivanka, no matter how different a career path we choose from our parents. People will always say, we wouldn't have gotten there if it hadn't been for our name. A name cannot get you through medical school. You have to do the work. You have to do the work in high school and in college, and to get to medical school, which is going to be more difficult than high school and college combined. The Trump name would not have helped if any of them had joined the military, which no one in the Trump family has ever considered doing. There are many, many things the Trump children could have done that would have left no one saying that they got that because of their name, but instead, they all chose the one thing that they could only get because of their name. They chose to go to work for their father. The father who Donald Trump Jr. didn't speak to for a year because of his treatment of his mother, and because according to the legal findings already made by the judge in the New York Attorney General's case against Donald Trump, the Trump children's father was running a corrupt business rife with corrupt and illegal business practices. They all dutifully played their part in their father's corrupt enterprise. Donald Trump Jr.'s testimony in the case began today and will continue tomorrow. The essence of his testimony in his first day on the witness stand was to blame others, the accountants, for the false valuations of Trump assets. Donald Bender, the longtime accountant for the Trump business, has testified that he used the valued accountant that we rely heavily on. Donald Trump Jr. also claimed to have no understanding of generally accepted accounting principles. He said he remembered hearing the phrase in accounting class in college and said, "I know nothing about generally accepted accounting principles." Prior to Donald Trump Jr.'s testimony, an expert witness testified that the fraudulent information used by Donald Trump's business prevented banks from collecting $168 million in potential interest on loans. Donald Trump, who has erratically come and gone from the courtroom, did not bother to be there today to support his firstborn son on the witness stand. Donald Trump Jr.'s mother couldn't be there because she died last year. But her words hung in the air in the courtroom as a sort of explanation for Donald Trump's absence today. He would give it to me because he had no idea what to do. Eric Trump probably has no expectation of a loving paternal eye gazing at him across the courtroom when he takes the witness stand. But when Donald Trump's favorite child testifies, the one who Donald Trump Jr. jealously describes as, quote, "daddy's little girl," then maybe, just maybe, daddy will show up. Leading off our discussion tonight is Adam Klasfeld. He is the senior legal correspondent for The Messenger. He was in the courtroom today, as he is every day for the proceedings. And Tim O'Brien is with us, a senior executive editor for Bloomberg Opinion and author of Trump Nation, The Art of Being the Donald. He is the host of the Bloomberg podcast, Crash Course, and an MSNBC political analyst. Adam, you are our eyes and ears in the courtroom today. What were the high points as you saw them?
Well, that quote that you led with, Lawrence, I had no understanding. That was followed by a rather tense pause and laughter. That's one of those details that just doesn't show up on the cold record. It's as you said with the GAAP, generally accepted accounting principles. That was one point that was part of what the Attorney General's office led off with when the trial started on October 2nd. They showed a snippet of Don Jr. testifying and basically denying detailed knowledge of generally accepted accounting principles, and that he basically said that he understood the acronym, but beyond that, it was basically accounting 101 at Wharton Business School, and so he had a kind of tight rope to walk here. He can't admit really detailed knowledge of generally accepted accounting principles because the Attorney General's office says that he was in charge of essentially having the statements of financial condition, making sure that they conformed to them. And instead, so when he had said that he was not that he did not understand the generally accepted accounting principles, it was in line with where the trial led off, and later in the day, it went on from there.
And Adam, Donald Trump Jr., as well as most of the other witnesses, are already, as is very common in civil cases, on the record in video recorded depositions, which normally in trials like this, sound pretty much exactly like what they're going to say in court.
Absolutely. This is something that happens very frequently, that they have had a deposition. That's why we got a little bit of a preview of where things were going and where we basically saw the Attorney General's counsel lead off questioning with. So that wasn't unexpected. Later on in the day, we went into further details about his relationship with Alan Weisselberg, who is a former CFO of the Trump Organization, and who he was in charge of essentially getting these statements of financial condition, signing off on them for a large number of, a lot of concern about the kind of thicket of conflicts of interest around the world. We learned today that 5 days before the end of Trump's presidency, he had gone back to the trust that he had said that he had steered to his sons. He had planned 5 days before going back into public life to be the trustee for that trust, which goes to show that he wasn't planning on another term. He was planning on leaving the White House 5 days before his presidency expired.
Tim O'Brien, you are the first to have experience litigating with Donald Trump over this very issue, which is to say the value of his holdings. He sued you when you wrote that he was not nearly as rich as he claimed to be. You, of course, won that lawsuit. Donald Trump lost badly. But you'd already seen the way this works when Donald Trump and his business actually enter the under oath process where the Trump game can't be played.
Well, and you discover when you start to just put documents in front of the Trumps, tax returns, banking records, other parties' assessments of their wealth, that they tie themselves in knot because they lie so frequently and so fluidly about everything. And they can't even be consistent about their lying. You know, recently, after I think one of the shows I was on with you last week, one of Trump's longtime advisors texted me and he said, you know, the problem with Donald isn't just that he lies, it's that he can't lie consistently. He'll say he's worth $6 billion or $2 billion or $1 billion, and I want to tell him just say 6, but he won't even stick with that story. And the reality is lying and dissembling is not a bug in the Trump Organization, it's a feature. And today, Donald Trump Jr. was Exhibit A in how they roll around that, because Donald Trump Jr. not knowing anything about GAAP allows Donald Trump Jr. and his siblings and his father to make up the numbers. And then he tries to pawn it off on his accountants. And I can tell you, because I've seen these documents, it wasn't pawned off on the accountants because the accountants wouldn't sign off on the document. They said, specifically because none of this comports with the standards that all the rest of us use to validate the numbers, we won't sign off on it. So the accountants never gave the blessing to this number. They simply said, okay, you've given them us, we don't agree with this, you can do what you want with this document. And that was the statement of financial condition that they peddled to banks and the media forever. The other thing to keep very front of mind here about the children is they are as ignorant as their father is. They are comically ill-informed about everything under the sun, and that's another reason they dissemble. And the children's relationship to their father is a hostage video. All of them are beholden to him. They have been since they were children. Don Jr., like the prodigal son, as much as he tried to distance himself from his father, inevitably got pulled back into his father's orbit. All three of the children, despite their conflicts about being in his presence, end up working for him. And now they've put themselves in harm's way because they're material witnesses against their father. If they perjure themselves on the stand, they're going to be in trouble. They're subject, Don Jr. and Eric are subject of the same penalties their father is, being exiled from the New York business community, from being able to do work in New York State, and possibly paying very hefty fines. That's what their allegiance to their father has won for them in the state of New York. And this weird kind of psychodrama that's playing out in the courtroom now is going to get capped at the end of next week by Ivanka's testimony. And as we all know, Donald Trump has a very perverse and troubling, unsettling relationship with his daughter. He talks about wanting to date her. He sees her as this sort of trophy he can parade around, as emblematic of his own good genes and his arrival in the world. But what's going to happen next Friday is that her siblings and her father's testimony will precede hers. And she's going to have to be very careful that the prosecutors don't simply carve her up like a turkey if she dissembles and lies about how the Trumps presented their financial statements to banks, insurance companies, and other third parties.
Tim O'Brien, Adam Klesfeld, thank you both very much for starting off our discussions tonight.
Thank you, Lawrence.
Coming up, the judges in both of the federal criminal prosecutions of Donald Trump issued rulings today about how classified information can be handled in those cases. That's next. Trump-appointed federal judge Aileen Mercedes Cannon indicated today that she might delay the trial in the case of Donald Trump's possession of classified documents because it could collide with the election interference case that Jack Smith is prosecuting against Donald Trump in Washington, D.C., which is set to begin in March as of now. Judge Cannon listened to Donald Trump's lawyers to try to delay the trial, raising concerns about having enough time to review the voluminous evidence, as they described it, to prepare for both of the upcoming trials. Judge Cannon seemed to acknowledge those concerns, saying, "I'm having a hard time seeing realistically how this work can be accomplished in this compressed time period." The Washington Post reports Prosecutor Jay Bratt argued that whatever the deadlines may be in other cases, those could all change. So it did not make sense to alter the trial date in the Florida case. Cannon sounded skeptical. "I'm not quite seeing in your position an understanding of these realities," Cannon told Bratt. The judge said she would rule on the schedule as soon as possible. Yesterday, Donald Trump was in Miami with his criminal defense lawyers to review classified evidence in a secure facility. Today, Judge Cannon and Judge Tanya Chutkan, who is overseeing Jack Smith's case about the 2020 election in Washington, D.C., each issued rulings about Donald Trump's access to classified evidence. The classified evidence is a minor component of the election case in Washington, D.C., and it is the essence of the case Judge Cannon is presiding over in Florida. To consider the details of those two rulings on classified evidence today, we're joined by Bradley Moss, a national security attorney who represents people who work in the intelligence community. Also with us, Glenn Kirshner, former federal prosecutor and an MSNBC legal analyst. He is host of the Justice Matters podcast. And Bradley Moss, let me begin with you and these two rulings on how to handle classified information in the two different cases. And this is one of those cases, I think it's the second time it's happened here in our legal proceedings, where I understand the rulings, but I can't explain them. I was sitting there going to write the script leading into this and thought, you know what? I'm going to let Bradley Moss explain it. These two different rulings by these two different judges, what do they mean?
Differences of experience and expertise, but there's also a confusing factor here in how Jack Smith's team approached this between the two cases. In the D.C. case, they filed what's known as a Section 4 motion under the Classified Information Procedures Act, which is this is the classified information that would be discoverable, that we would ordinarily turn over to a defendant. Because it's classified, it's a certain sensitivity. We want permission under the statute to provide basically unclassified substitutions. Not the actual document, but here's the unclassified summary substitutions. They provided that to Judge Chutkan. Judge Chutkan reviewed everything under seal in camera by herself. She had an ex parte by their own hearing with Trump's lawyers just to be safe, but she concluded, no, I'm good with the government's submission. You can give the substitution discoverable information to Trump. In Florida, it was under Section 3, which is not the same thing. It's not that proactive motion to delete. It's talking about the larger overall protective order. And there became this debate over the scope of the provision and if it could apply, to these defendants. And it's not even talking about Trump. It's talking about De Oliveira and Nauta. And so it became confusing to what extent that was really applicable. I think this will get cleared up with Section 4 motions eventually before Judge Cannon in Florida, but it was a very odd set of coincidences to have these two different rulings with two different types of motions.
Yeah, and Judge Cannon said she's ready to hear a Section 4 version of this, which was not what she was hearing today.
Correct, which was, again, I don't know why Jack Smith's team approached it that way. There certainly was probably a strategy behind that. I certainly expect they will be doing this at some point. I think they were fighting here on a procedural issue that Nauta and De Oliveira wanted access to stuff that really isn't relevant to their charges because they're not charged with Espionage Act violations. They're on the obstruction angle. But, it came down weird. We're going to see a lot of this with Judge Cannon. I'm looking forward to finding out what she sets as this new date. If she changes the deadlines, the trial date in that case, I don't anticipate it will be as long as some are fearing.
Glenn, on the trial schedule, prosecutors are saying to Judge Cannon, look, you just have to ignore the other cases and set your own schedule because, in fact, you have no idea what roadblocks or changes might come up in the scheduling of any of these cases, that none of these schedules are locked in, and so you just have to go ahead and schedule it. What was your reaction to that?
Lawrence, I've often had defendants who were pending multiple trials, sometimes in multiple jurisdictions, and there is this phenomenon where defense attorneys will play one trial date against the other. They'll go into one courtroom and they will complain about how burdensome it is to prepare for the other case. Then they'll go in the second courtroom and say how burdensome it is to prepare for the first case. And I will tell you, this is not a criticism, nor am I accusing defense attorneys of acting in bad faith when they do this. But sometimes I have seen both trial dates get continued because they play one against the other. And can I also say, Lawrence, I'm really relieved that you asked Bradley the question about these two SEPA rulings because he's the subject matter expert. But, in preparation for tonight, I read these two motions back to back, and I wouldn't presume to give your viewers homework. But when you read these motions one after another, you get the sense that, you're almost compelled to ask yourself the question, what does Judge Cannon have against the Office of Special Counsel? Because for 15 pages, it's almost nothing but criticism of special counsel. Some of it feels gratuitous, even bordering on snarky. And what it drove home for me is that maybe there was an opportunity lost by Jack Smith deciding not to file a motion to recuse, because a recusal motion, the standard under the federal law, couldn't be lower. It is simply if a judge's impartiality might reasonably be questioned. If so, the judge shall recuse. It would have been nice to have that litigated, have some sunlight on it, have the trial court resolve it and the appellate court resolve it. Then we could move forward without this lingering concern, especially because, as we've been discussing, it feels like she may want to kill this trial date by the death of 1,000 continuances. So I think her impartiality continues to be in question.
No, I agree with you on that, Glenn. Her attitude toward Jack Smith and the special prosecutor staff, it just seethes through almost every sentence she's writing in their direction in any ruling that she makes. It's always there. Glenn Kirshner, Bradley Moss, thank you both very much for joining us tonight. Thank you. And coming up, Tennessee State Representative Justin J. Pearson will join us next, and he will join me Friday night in Boston as the guest of honor at the Action for Boston Community Development annual event. Representative Justin J. Pearson is next. The White House has announced that President Biden and First Lady Jill Biden will travel to Lewiston, Maine on Friday to mourn with the families of the 18 people murdered in this year's deadliest mass murder. More than 1,000 people gathered on Sunday for a memorial service at the Basilica of Saints Peter and Paul in Lewiston. The mass murderer's family warned local law enforcement of his declining mental health while having access to firearms 5 months before the mass murder. The Associated Press reports the mass murderer, quote, underwent a mental health evaluation last summer after accusing soldiers of calling him a pedophile, shoving one and locking himself in his room during training in New York, officials said. A bulletin sent to police shortly after last week's attack said that the murderer had been committed to a mental health facility for 2 weeks after hearing voices and threats to shoot up a military base. Our next guest, Tennessee State Representative Justin J. Pearson, is a graduate of Bowdoin College in Maine, and he said this: "I was privileged to attend Bowdoin College in Brunswick, Maine, and now mourn the lives lost during the senseless violence committed by a mass shooter at a bowling alley not very far from my alma mater in Lewiston, Maine. I stand in solidarity with these survivors as they grapple in the aftermath of this horrific act and pray for the healing of those injured during the attack in the Lewiston community. Gun violence is a national epidemic. It is a preventable epidemic. The deaths caused by gun violence are a product of the moral cowardice of people in power failing to protect innocent people. Elected leaders must prevent these tragedies from Memphis to Maine. As legislators, it is our duty to do all we can to prevent these atrocities by passing laws that protect people, schools, and communities." Joining us now is Democratic State Representative Justin J. Pearson of Tennessee. Thank you very much for joining us tonight. I thought of you when I saw the location of this event, knowing that you graduated from Bowdoin, spent 4 years there in Maine. Please just feel free to share your thoughts with us tonight about what has happened in Maine.
Lawrence, thank you so much for the opportunity to be here tonight. And I am, again, devastated and heartbroken by the preventable loss of life for the folks in Lewiston. We cannot be desensitized to the traumatizations that mass shootings continue to have in our community. Maine is one of the most beautiful places I've ever been. It was a place that helped to nurture me and to grow me into the person that I am. And I know that the folks there are resilient. I know they are beautiful people. But this tragedy has really shown us that we have more to do to protect our communities. And a lot of conversation has been about how do we protect schools, but the reality is children go to bowling alleys. The reality is grandparents and parents take their families out to have nights out to ensure that we prevent people from having access to weapons of war that should not have them. And we can never allow ourselves to believe that this is normal. We can never allow these tragedies and unfortunately these 18 funerals that are going to happen in Maine and several funerals, the 6 funerals that happened here in Tennessee after the Covenant School shooting and the funerals that we see week after week in my district due to the everyday epidemic of gun violence to be normalized. This is a tragedy. And we have to remain sensitized to the harm and to the effects of the National Rifle Association, of the American Firearms Association's policies that are making sure that elected leaders do nothing in the face of the most significant killer of children in our country. We've got to do it. Truly devastating for the people in Maine and across our country who are suffering from this epidemic.
As you did in Tennessee, when you rose to try to, in the legislature, to try to bring to the attention of the legislature and the elected representatives there, their moral responsibility on this issue. You've mentioned tonight that it's elected officials who must act. We saw something so unusual in Maine after this. Representative Congressman Jared Golden, who changed his position on this and asked for forgiveness for his past position. Let's listen to what he said.
I have opposed efforts to ban deadly weapons of war like the assault rifle used to carry out this crime. The time has now come for me to take responsibility for this failure, which is why I now call on the United States Congress to ban assault rifles like the one used by the sick perpetrator of this mass killing in my hometown.
That's something we don't normally see after these events.
No, that is not something that we see, and it is a pattern that the Republican Party and conservatives should follow, which is you have been wrong, and it's time to be right. You have been wrong about the issue of gun violence prevention. You have been wrong about assault weapons. You have been wrong about extreme risk protection orders and red flag laws, and now is the time to be right. And hopefully you do not have to have 18 people in your community killed by a mass murderer with an assault rifle for you to change your position. There's been enough bloodshed. There's been enough people who have died. There have been enough funerals. There's enough guns and gun violence that has impacted our community this year alone. Over 500 plus mass shootings have occurred. Thousands of people and communities have been shattered. We don't need to wait or waste any more time listening to the National Rifle Association. They don't care about our children. They do not care about our communities. They do not care about protecting us. We are responsible for protecting our communities. And for legislators to only pray when you have the power of the pen and you have the power of the positions that the people have put you in, you have a responsibility to do more. And that is to change this status quo. And we must do everything that we can to prevent these tragedies from occurring in the first place and not just praying after they happen. And so this is one representative who has changed his position. There need to be thousands more to have moral courage because we are right. We are morally right and we are politically right. The people in our communities want to see laws passed and created and crafted that make us safer, and we need to do everything we can to pass those across this country.
Representative Justin J. Pearson, thank you very much for joining our discussion tonight, and I can't wait to see you Friday night in Boston at the Action for Boston Community Development event.
क्या मांगू मैं तुझसे भोले, दूर हो गए संकट ये सारे। क्या मांगू मैं तुझसे भोले, दूर हो गए संकट ये सारे। नाम तेरा लिया तूने सब है दिया, नाम तेरा लिया तूने सब है दिया। सारे संसार पर है तेरी नजर, ओ शिव शंकर, ओ शिव शंकर, ओ शिव शंकर, ओ शिव शंकर। तेरे दर पे आने से ही दिल को चैन मिलता है। जब जब देखूं तुझे मैं मन मेरा खिलता है। देखूं मैं जिधर तू दिखे है उधर, देखूं मैं जिधर तू दिखे है उधर। तूने खुशियों से भर दिया है दिल का नगर, ओ शिव शंकर, ओ शिव शंकर, ओ शिव शंकर, ओ शिव शंकर। ओम नमः शिवाय, ओम नमः शिवाय, ओम नमः शिवाय, ओम नमः शिवाय। बिखरा था टूट के पहले तूने मुझको संवारा है। मेरा भोला साथ खड़ा था, मैंने जब भी पुकारा है। ना समझ बेखबर तेरी सब पे नजर, ना समझ बेखबर तेरी सब पे नजर। संग तू है खड़ा तो है कैसा शंकर, ओ शिव शंकर।